Hello, everyone, and welcome to this ninth edition of Soundbites. My name is Stephen Reagan, and I am the principal privacy consultant at Rangu. Again, with these Soundbites, I'd like to give an update on some current events, current trends that are happening in the privacy and data protection world. And the past couple of weeks have been very busy. We have seen the UK get adequacy. That's kind of a sigh of relief that you hear emerging from the United Kingdom, along with maybe some chance about it coming home. Uh, Along with that, we had the publication of the new standard contractual clauses. This was a welcome update from the European Commission. And then, in conjunction with that, a few days later, the European Data Protection Board published their recommendations for supplementary measures. And so, really, the focus of this episode will be on data transfers and kind of the context and the environment in which these restrictions, the possibilities for data transfers, which still exist, are really arising. And I want to frame the context, frame the situation by briefly discussing a study that was recently published by the consulting firm Frontier Economics. This was a study commissioned by Digital Europe, a trade association representing digital transforming industries in the EU, and there were kind of some startling conclusions that the study drew. Of course, these are just projections trying to predict the future, but in some sense, they kind of demonstrate what could happen. And the study analyzed two scenarios. The first scenario considered the current trend towards moderate increases in the restriction of data flows. So kind of this trend potentially towards data localization, where organizations are forced to keep, store, analyze, and process data within the European Union, really on the back of this Schrems II decision that is almost a year old at the recording of this soundbite. And then the second scenario assumes the EU will establish GDPR compliant transfer mechanisms like the standard contractual clauses recently published, as well as considering these scenarios of implementing adequacy decisions and how these might be utilized. So, looking at that first scenario, the more restricted scenario of kind of a stronger form of data localization. And the study concluded that with some real jaw-dropping numbers, that the economic damage could be around 2 trillion euros by 2030, resulting in 2 million fewer jobs and an annual reduction in GDP across Europe of an estimated 2.5%. The second scenario, assuming kind of a lesser restriction or a less strong form of data localization, which potentially kind of seems to be what is emerging with the publication of these standard contractual clauses, providing these mechanisms for data transfers outside of the European Union, as well as considering the potential route of adequacy decisions, as we've seen the UK getting their adequacy decision not too long ago. This scenario is expected to boost EU exports by 2% and contribute to 0.6% annual GDP growth. So you're going to have these two potential scenarios. Of course, really in some sense we have these advocates for the kind of free flow of data across and outside of the European Union as a facilitator for business growth and digital transformation. As the scenario kind of currently stands, a lot of these service providers are based in the United States. The Schrems II decision invalidated the Privacy Shield, this kind of adequacy or transfer mechanism for data transfers from the European Union to the United States. The Court of Justice invalidated this transfer mechanism, and really, with these standard contractual clauses, which I will dive into in a bit more detail a little later on in this soundbite. but it really puts an onus on organizations to make independent assessments of third country legislation. And this is really challenging for organizations that don't really have resources to dedicate to these assessments and to this analysis, really impacting small and medium enterprises. Around 70% of the 5,400 organizations that had certified in the Privacy Shield were small and medium enterprises. So, as the situation currently stands between Europe and the United States, these small and medium enterprises are really greatly affected. And so the environment kind of, is set up at the moment for larger organizations who can conduct these independent assessments. And again, so it's a bit of a challenge, kind of thinking about what type of framework for privacy and data protection Europe is really seeking to chart. We have the emphasis on these fundamental human rights, privacy and data protection as fundamental human rights here in Europe. So this is one justification for the court's decision. On the other hand, we have these digital transformation projects, activities, and where Europe is really seeking to become a leader in this space, and potentially, this provides another justification and another reason to restricted data to being localized and staying within Europe. Again, that's the kind of the contextual situation. And now I'm going to dive a bit deeper on some of those mechanisms that allow us to continue to transfer data outside of the EU to third countries, not just the United States, but India, China, and these other third countries that don't have an adequacy decision. But before that, I'm going to turn to the UK adequacy decision and explore it just a little bit in detail before turning to those SECs, the supplementary measures published by the European Data Protection Board, and before concluding with a bit of an exploration on where Europe and the United States stand in their negotiations over an updated Privacy Shield. All right, so with that kind of contextual framing of the situation about data transfers, I'm not really here to take a position on whether the free flow of data is something that we should be encouraging and promoting. I'm just going to discuss a bit about these transfer mechanisms that make data transfers possible. So again, we have these standard contractual clauses. These place a really challenging onus on companies who want to export data to third countries outside of the European Union. I know often the focus is on America, as that Schrems II decision focused on the Privacy Shield and the transfer mechanism between Europe and the United States, but that decision also had ramifications for other third countries that don't have an adequacy decision. So thinking about India or the Philippines or China, all of these countries, now they have these standard contractual clauses and the supplementary measures as guidance for ways to transfer data. But again, that basically requires organizations to make an independent assessment, essentially, of the adequacy of those third countries' legislation. All right, that's really challenging for organizations. And in the instance where the European Commission could not or has not done it, they are putting that obligation on organizations. Again, really big challenge. But I'm going to focus right now and briefly on the UK adequacy decision, because adequacy really simplifies things for organizations. With this adequacy decision, organizations in the UK and organizations in Europe that want to transfer data to the UK, they can do that freely without implementing any of these standard contractual clauses or supplementary measures. And so for a bit of a brief background, the year 2020 was a year of transition where the UK and Europe really tried to separate themselves, create a clear delineation of this break of the UK from Europe, and so of course, trade was a big issue, and so were data transfers. So for the entirety of 2020, the European Commission was examining the UK's laws to decide whether or not they considered the country adequate for purposes of data protection, that essential equivalence determination. Well, the European Commission could not reach a decision. It really left organizations in a bit of flux there at the end of the year, at the end of 2020. Fortunately, for UK organizations, this trade agreement was reached right before the end of the year. All right, organizations don't have to do anything, and there will be an interim period of 6 months in which we would hopefully get an adequacy decision. Well, we're really pushed up to the end of it, and on June 28th, the European Commission published its decisions, granting the UK adequacy, and there was actually a set of two decisions, one on the GDPR and the other on the Law Enforcement Directive. Now, many of you may be wondering, well, the UK has basically their own form of GDPR. It seems a really clear-cut and straightforward decision for the European Commission. There are some underlying issues, in particular the fact that now, despite the UK having its own form of GDPR that essentially mirrors the European version, almost article for article, the UK can now chart its own course and basically do what it wants in the areas of privacy and data protection. There's a big concern in Europe about how the UK's laws would develop, as well as concerns about onward transfers, for example. Now the UK can make its own adequacy determinations. What if those adequacy decisions or determinations deviate from those of the European Union? How would some of these issues be addressed? And so one way that these issues are being looked at and addressed is that the decision has what's called a sunset clause. So it's the first of its kind, where after 4 years, the adequacy decision will have to be reassessed. So this adequacy decision lasts for 4 years. Organizations now can transfer data from Europe to the UK without any of these supplementary measures. Kind of good for organizations at the moment. Still a bit uncertain. Well, I guess we have some certainty now, but how the laws in the UK will develop will be continually assessed, and so it doesn't necessarily have to be that this adequacy decision will last for 4 years. If the EU sees the UK falling short of some of its obligations, or the adequacy decision is challenged in court, it could be reassessed, looked at, overturned. But for the meantime, we have this adequacy decision, a bit reassuring. Now we'll go just a bit in detail on some of the other issues that were kind of some hang-ups. In particular, one was over this immigration exemption within the Data Protection Act of 2018 that essentially said that when data was processed for purposes of immigration, the fundamental rights and freedoms of individuals did not have to be taken into account. This immigration exemption was actually deemed unlawful by the UK Court of Appeals a few months ago, and Recital 6 of the agreement specifically excludes any transfers of personal data to the UK for immigration control. Recital 277 of the agreement kind of states some of the conclusions for the agreement, really based on the relevant UK domestic regime and its international commitments, in particular its adherence to the European Convention on Human Rights, as well as its submission to the jurisdiction of the European Court of Human Rights. Continued adherence to such international obligations is an important element of the assessment on which this decision was based. Again, the adequacy decision comes to a conclusion really by stating that, quote, where the Commission has indications that an adequate level of protection is no longer ensured, the Commission shall inform the competent UK authorities, again, and may suspend, repeal, or amend this decision. So, we have sunset clause at the end of 4 years, at which time the adequacy decision may be renewed. In that interim period, we will have to see how the UK laws develop. And so, again, this is within this context of almost this brazen decision of the United Kingdom Task Force on Innovation Growth and Regulatory Reform issuing its recommendations to the Prime Minister almost in conjunction with this adequacy decision, really saying, and I quote now, how the UK can reshape its approach to regulation and seize new opportunities from Brexit with its newfound regulatory freedom, with a section in the report titled, quote, again, replace GDPR with a new UK framework for data protection. So, for those inclined towards entertainment, this may be an interesting area to watch for organizations that transfer data from Europe to the UK. Also want to, of course, keep an eye on this space. But for the meantime, all right, so we can transfer data from Europe to the UK without any of these safeguards, standard contractual clauses, or supplementary measures. For third countries without an adequacy decision, you have different considerations. And so in the next section, I will explore kind of not exactly and in detail, but maybe an overview of the standard contractual clauses, as well as the supplementary measures, and how organizations can maybe start to think about ways to manage the situation. All right, so for organizations who transfer data outside of the European Union, on the one hand, if you are in the UK, good news for you, you have an adequacy decision. Adequacy decisions are one mechanism by which data may be transferred. You're transferred into a third country without an adequacy decision. There is kind of some good news. So the Court of Justice in that Schrems 2 decision said standard contractual clauses are still valid, while saying supplementary measures should be implemented. What those supplementary measures were, we haven't known for nearly a year since that decision, but in the past few weeks we have gotten the update to the standard contractual clauses, as well as recommendations on the supplementary measures. So first I'm going to start with just a brief discussion of the SCCs before turning to really that step 3 assessment under the recommendations, kind of just to explore that just a little bit, really looking at this risk-based approach. That might be a welcome sign for organizations. So first, the standard contractual clauses, they were issued on June 4th of 2021, and they come into effect on June 27th of 2021. So from June 27th, organizations can use the standard contractual clauses. Besides that, if you have existing standard contractual clauses or the old legacy standard contractual clauses from before, these new forms of the SCCs, you can continue to use those for new data transfers for up to 3 months. So up until September 27th, those legacy existing standard contractual clauses can be used. And then data transfers relying on the old standard contractual clauses, those can continue for up to 18 months until the end of 2022. By then, the new standard contractual clauses will have to be used and implemented for organizations. The standard contractual clauses are are definitely a welcome. The last set were issued in 2010. So now we have new modules envisioning new forms of data transfers that weren't conceptualized in the last edition. So now we have framework for controller-to-controller data transfers, for controller-to-processor transfers, processor-to-processor transfers, and then the fourth module is processor-to-controller data transfers. And one major update is this This is docking clause as well, trying to simplify and make it easy for organizations to adopt contracts or become new parties to existing contracts. And so that's really what that docking clause is all about. Besides that, we have these new annexes, and it's really trying to make it as easy for organizations as possible to implement the new standard contractual clauses, really creating a framework where organizations can go to these annexes and modules and implement your contractual provisions within this framework, and really standardize it in some sense. So besides that, we have this is the Court of Justice saying, okay, you can use the standard contractual clauses, but you have to implement supplementary measures to ensure essential equivalence with the laws in the European Union. So what were those supplementary measures? Back in November, the European Data Protection Board issued a draft recommendations. Those were recently adopted. And it's really a 6-step approach. So step 1, know your transfers. Step 2, identify the transfer tools on which you are relying. So if you are relying on standard contractual clauses. Besides that, for organizations doing transfers intra-organizational, so within organizations, you might want to consider binding corporate rules as your mechanism. Other than that, we have derogations under Article 49. Those derogations can really just be used for one-off data transfers, not for recurring data transfers, or data transfers that happen regularly and often. Besides that, we have the certificates and codes of conduct, but none of those have yet been validated or given some type of certification. So, as it currently stands, standard contractual clauses, binding corporate rules, derogations are your options for transfer tools. Step 3, assess whether the Article 46 GDPR transfer tool you are relying on is effective in light of all circumstances of the transfer. So, step 3 is the big one. Assess the laws in the third country and make your transfer assessment, document it, and so then you can provide this document in the case of an audit. Step 4, adopt those supplementary measures. Step 5, procedural steps implemented to effectuate these supplementary measures. And then step 6, reevaluate at appropriate intervals. So I'm just going to explore a little bit more in depth this step 3 and then the transfer and the assessments that organizations have to make. So again, this is a really big burden in some sense for organizations to do what the European Commission could or has not done, really make a finding of some sense adequacy, without a finding of adequacy, implementing supplementary measures and what those are. And from the outset, this requires, again, this transfer impact assessment. It's kind of nice to see that the European Data Protection Board has embraced a subjective risk-based approach, so organizations can consider their own subjective experiences with public authorities and access requests. Absent access requests, is a really good indication that, okay, maybe, organizations can go forward with these data transfers. With that being said, there must be also a consideration of the sector within an organization is embedded. Has there been access requests within the sector that your organization operates? Other things that organizations should consider, of course, are the types of data transferred. The United States government issued a report in September of 2020, really kind of laying out what data organizations they're in some sense concerned with, like HR or employment data. This was really not high up on the list of concerns for the US government. So maybe you kind of include in your assessment white papers and government findings. Kind of cuts against on the other end. It's like, of course, the United States government is going to say that. They're going to try to, create a context in which organizations think, oh yeah, we can transfer data, and then it's publicly, or it's accessed by public authorities. So Yeah, there's again a number of considerations that organizations are having to make in these assessments. And these assessments should be documented and auditable by supervisory authorities, really describing the laws and practices of the third country that are relevant to the transfer, the procedure that was followed to produce the assessment, and the dates on which the assessment and any subsequent checks took place. Going beyond this assessment, what are some practical things that organizations can implement? These safeguards, technical and organizational mechanisms to protect data, of course. One is end-to-end encryption. This was one of the safeguards that was at issue in the French Doctolib case, where the court found that this form of supplementary measure was in some sense suitable. Another issue that the court was concerned with in that case again was the data. What type of data was transferred? Was it sensitive data or was it not? If it's not sensitive data, all right, that really in some sense cuts in your favor. But again, it's one among a number of variables that organizations are having to consider. Another potential tool that can be used is contractual provisions for the importer to, as well as financial resources laid out for the importer to challenge access requests by the government. All right. So now you kind of have the environment, the framework, the context in how this situation is developing, data localization, soft, hard forms of data localization. Organizations want to continue to transfer data. They're going to continue to transfer data. How can they do this? One hand, adequacy decision for the UK. Okay, really good for organizations in the UK transferring data from the EU to the UK. For organizations located in third countries. Okay, what are some ways that you can continue to transfer data? Standard contractual clauses with the implementation of these supplementary measures. Other than that, for organizations, that's really the way to go about doing it. And, we're all processing it. We are all in this space of really trying to deal with this difficult situation. The standard contractual clauses, the recommendations, they are all new. Even the GDPR 3 years on, we are still learning about what exactly it means. Courts are interpreting it. All of these things. Organizations are doing their own forms of interpretation, really effectuating how the law is operating in practice. The last thing I will mention is that there is hope for organizations, at least in the United States, that an update to Privacy Shield will be coming in short order. There was a recent summit between the EU and the US, which was concluded with the creation of the EU-US Trade and Technology Council. Well, this council received top billing Christopher Hoff, the lead negotiator for the United States, in a recent LinkedIn Live session with the International Association of Privacy Professionals. That negotiations, they are not at a beginning stage. These negotiations are ongoing, and we are not starting from point zero. We had the old Privacy Shield. There were just a few things that created challenges for the Court of Justice in its determination, and evidently, I think quote unquote, negotiations are intensifying between the United States and Europe. So definitely something to keep an eye out for. This is really data transfers and adequacy and transfer mechanisms is really probably something that should be done at the governmental level. Again, it's really difficult for organizations to do this independent assessment. It's easier for larger organizations who have these resources to expend. But it really creates a challenge and a barrier for small and medium enterprises to operate in this space, and we really don't want to create an environment or a context where it's just massive players that shut out those mom and pop shops. Um, and a last thing to note is that 70% of those companies that were in the Privacy Shield and were certified as Privacy Shield organizations were small and medium enterprise organizations. So 70% of nearly 5,400. And the last thing to note is that many of those organizations will remain in the Privacy Shield. That's probably a good idea for organizations to certify, because that's better than nothing. That it indicates that there is a commitment to privacy and data protection. There are additional protections for individuals provided by the Privacy Shield. At the moment it doesn't raise up to that level required by the European Union and cannot be relied on. But nonetheless, it indicates a commitment to the protection of privacy and data protection. All right, so with that, it's kind of a long-winded ninth edition of the Soundbites. I hope it provided a bit of clarity and kind of an opaque situation, really exploring some of the challenges and difficulties, as well as the ongoing things that are going on within the privacy and data protection field. So until next time, thank you. See you then.